We got two videos that I came across while doing some things around the house that I found interesting in lieu of certain content creators / influencers getting ready to go through the ringer when it comes to getting sued. Now, these videos can be found over at Court Archives. Please head over to the channel, subscribe, especially if you want to listen to these two videos we're about to watch without my commentary. But if you want to listen in, what's up, my friends? And welcome back once again. If you're new to the Jaberhood, we like to get together and tune into topics that ain't got nothing to do with us. And that's what we're about to do now. So if you have not subscribed, go ahead and do so. If you're already a member of the Jaberhood, I know some of us like to watch court TV. Something about listening to court TV while doing an Excel spreadsheet made me feel like I was being very productive. So let's get into these deadbeat ass daddies.
Michael Turner, get Mr. Blumberg present on behalf of Ms. Turner, who's also present by Zoom video. This is set today for a show cause hearing. Mr. Blumberg, I did review your show cause motion. You're alleging that Mr. Turner's violated the prior order of the court by disposing of assets and essentially moving assets or putting them out of the reach of the court's order. Anything that you wanted to state for the record on that?
Yes, Judge. Besides the violation of the order for trying to dispose of assets, he was required by that same order to pay all of the household expenses that he historically has paid. And the fact of the matter is he's failed to do that.
I never realized that girl sitting in the back. Oh my gosh, I never saw her. I've always been just concerned, focused on this, and this, but never her.
We have quite a list of things that he was required to pay that he has not paid. I think it's relevant for the court's consideration today is that Mr. Turner apparently is going to trial on either in the next week or two on delivery of methamphetamine. So I don't know how that impacts on where we are today, but clearly a condition of his bond is that he not violate any laws of the state of Michigan or any orders of the court. And it's clear to me that he has done that. So we're prepared to go forward and explain to the court through my client's testimony of what bills he's not paid, including rent for the last 8 months. Whenever
I watch these, I'm always like, man, I hope that I get blessed with a partner that I do not have to separate from and go through any of this. Because I mean, thinking about separating a household, children, finances, still having to be connected to your past person for them to pay your bills, because you do kind of have to let them know what's going on, or just them knowing about it. Just is a lot to have to go through because you're still connected to them and they provided a lifestyle for you.
Yet he's conducting business. He has his own business and he's chose not to use that money to support his family. There's also a temporary child support order that he's not paying. So clearly he is willfully defying the orders of this court.
All right, in terms of the disposal of assets, what are you asking the court specifically to order with regard to that or the non-payment? I mean, if the court were to find Mr. Turner in contempt, what's the remedy that you're asking for? Because I suspect what he's going to say is that he doesn't have the money to pay the household bills because of his other matters. And that's one issue. The other issue is the disposal of assets. So what if the court were to find he's in contempt, what are you asking me to do on those issues?
Well, I think the court would fine him, perhaps incarcerate him. These are all things that are within the discretion of the court in a contempt proceeding. But perhaps even more importantly than those two things is that we believe he does have the money. He's collecting money for jobs that his company's doing, and he's not performing the work. He tells the Michigan State Police that there's some trust account in which he's holding these funds. Those funds, if they exist, would be available to meet his obligations under the court order.
Okay. All right. Thank you. Mr. Turner?
Yes, so I'm going to deny hiding any assets. I haven't transferred any assets since the motion was filed on 4.
He looked like he was hiding money. And he looked like he was the type who was using his business as a front. He told his lady everything when stuff came crashing down. She was like, you know what? I know what I'm going to use against your ass so I can get the money that I'm owed. Now he's like, I ain't got nothing. Nothing, judge, nothing.
Was it 425? I believe what they're referring to is the Durango that my company previously owned. Turner Handy Home Services began its wind down period 3/31, and with doing so, I disposed of the Durango that's in question. I sold it, and then I dissolved the company 4/22, which was 3 days prior to Mrs. Turner filing for divorce.
Because I knew everything was on the way, and I did not want to get caught up in having to pay her no money. So all of a sudden, I don't got a business, don't know what to tell you.
I have been financially unable to pay her bills.
Oh, of course. Yeah.
Because my company dissolved, I was forced into homelessness on 3/1 when she filed a PPO. My company collapsed as a result. I've pretty much been unemployed all year. I was certified homeless on 5/10 by NEMSCA. They assisted me in finding an apartment on 5/24, and NEMSCA has paid my rent until 10/31, just until last month. I just started a new business, 9/18.
If that's the case, why did you go get a job instead of being homeless? Why wouldn't he go get a job instead of keep on starting these businesses?
Kind of getting things, going with that. There was a child support order that was put into place, awarding arrearages back until May for a total of $5,298.50. As of November 1st, I did pay my child support plus arrearages in the amount of $1,110. Over the course of the summer, I was doing some odd jobs here and there, and I was able to make a little bit of money, and I sent whatever I could. I sent money on 4 different occasions for a total of $800.
Okay. All right. Mr. Blumberg, any response to that?
Well, yeah, certainly if Mr. Turner felt that he couldn't comply with the court's order, it would have been incumbent upon him to seek relief from the order. He's never filed a motion to relieve himself of the obligation that from the order that the court signed. The fact is, there's 2 young kids involved here that are not receiving child support from their father, who's otherwise physically able to work.
Get a job.
I've heard this excuse from the beginning of this case. We understand, again, that he has represented to the Michigan State Police that there are funds available, that those funds are being held in some trust account.
Get the funds out.
Again, I don't know if that's truth or just
made up,
pure sophistry on his part.
Lying, making up shit.
In the meantime, it's these 2 kids and my client that are the ones that suffer because of Mr. Turner's refusal to support his family.
Okay. Well, I mean, first of all, I guess there's 2 different issues. Well, there's 3 different issues here. Number one, the child support issue. That's a matter that would, I'm assuming that's through a friend of the court. Is that right, Mr. Blumberg? Is the child support order through that? I know
Yeah.
Okay.
Yes,
so the enforcement mechanism for child support would be through the friend of the court, and to the extent that that's not occurring, I'm sure that friend of the court is following that part of it because they've got an obligation to. In terms of any bond violations in the criminal matter,
you can be violated.
I think that's something that would need to be reported to the prosecutor's office for determination of whether they would seek an ex parte order to revoke bond. What is, I think, appropriately before this court is the court's order that was entered, which did prevent the disposal of assets and the requirement for payment of household expenses. So I think in order to make a determination about whether to what extent Mr. Turner should be held in contempt on that, I think the court would need to conduct an evidentiary hearing. Number one, I would need to determine this issue of when the Durango was sold, who it was owned by, and there's also Mr. Blumberg in the messages that you attached, which I think we would need to have an evidentiary basis to admit, but assuming that they were admitted, there's also an indication in there that there was $8,000 that was also moved to avoid, specifically to avoid the divorce, because that's in that text message. I moved this because somebody told me to get it out so that it wouldn't be part of the divorce.
Got your
Which
ass.
would clearly be a violation of the court's order if that's true and if that is admissible.
He probably be like, no, that ain't true. The $8,000 I had used to buy a private plane because I had decided I was going to be a pilot for romantic occasions, fly people around the city because I'm trying to make the money. Okay, I'm trying to make the money to give to her, but y'all stopping me with this. What are you gonna say?
But I think the court would need to make evidentiary findings on that to hold Mr. Turner in contempt for the Durango and or that $8,000 or any other assets.
We'll sit up here and lie.
So I'm going to set this for a 2-hour evidentiary hearing. Mr. Turner, to the extent that you have documentary evidence as to those issues, you're going to need to bring that to the court. It's unlikely that just denying it is going to
satisfy the court.
Provide sufficient weight. You're going to need some documentary evidence. So anything that you have to defend against these claims, you're going to need to bring to that contempt hearing.
What would he have?
And then, Mr. Blumberg, obviously, you'll bring the evidence that you have.
Certainly.
The court will set that for a hearing date and notify the parties of that. Mr. Turner, you've been raising a question. Do you have a question?
I just wanted to clarify a little bit about the messages that were attached. The $8,000 was a communication between my client and I. What had happened is, obviously, I made some mistakes in my business.
What had happened was, mind you, boom, boom, you feel me? And then pat out, cha-ching. So, that's what happened, and that's where the money went. What?
Business. I was given an $8,000 advance from my client.
For what?
And subsequently fired me from the job, and they did a chargeback on their credit card, and it pulled that $8,000 from my account, leaving my account very, very negative, and that's what led to the dissolvement of my business. So that $8,000, I never actually, I had it for a short amount of time, and then it was taken back.
Show us proof.
Yeah, that's fine. I mean, I understand that's your position. You're going to need, like I said, to bring some documentary evidence showing that that's what actually occurred, which there should be some evidence of that.
Yeah.
There is. Yep.
So
if you
that's
guys
how we'll proceed on that. The court will set that for the soonest date possible because I know timeliness is an issue here. In terms of proceeding with finalizing the divorce, because this was also set for a status conference here today. I know we've got these issues outstanding, but Mr. Blumberg, how do you envision us getting to a resolution here?
Well, there was a hearing in front of the referee. I don't know that Mr. Turner filed an objection to the recommendation or not. Certainly, again, how this criminal matter turns out, again, whether he's going to trial, I looked at the court's docket. It looks like it's coming up fairly soon. That's going to obviously have some impact on the ultimate custody and parenting time.
Right.
Okay. All this mess, all this trouble, still owe money. God.
I'm going to set this for a status conference at the time of that contempt hearing, and let's see where we're at that point and whether or not the other issues have been resolved. Mr. Turner, is there anything that you wanted to put on the record regarding scheduling to resolve the divorce matter? I mean, at some point, this divorce is going to need to get finalized.
Yeah, I mean, I don't have any withstanding issues. I'm not sure why it's being drug out so far. We've hashed out child support, custody, all that. I've offered to give Mrs. Turner to the Durango if that's what she wants. I don't really want to fight about this anymore. I'm just ready to wrap it up. You know what I mean?
Okay. Well, then I would suggest that you get in touch with Mr. Blumberg to see how that can happen.
I would if he would return my phone call. I've reached out probably a dozen times to no avail.
Okay.
All right. That's all I have for today. The court will send out notice of the date and time of the...
As you know, and I know that you read our motion as well as the response, my client Danielle works part-time. The parties have one child, a 2-year-old. My client is 34 weeks pregnant. The baby is due in early January, so about 6 weeks from now. The father is a lawyer at a large law firm in town, a very prestigious law firm. There are two things that we wanted to say in response to the answer filed by Mr. Campbell, the first thing is that Danielle very much wanted to save the marriage. She didn't want to leave the marriage, even though he describes the divorce as being a mutual decision. It was not by any means.
Because who gets a divorce at 30 some odd weeks pregnant when you're about to have the baby? No, Alex, this was you.
Response indicates that the parties fell out of love. And in her view, she didn't fall out of love. This is a situation where he simply left the marriage unilaterally. She asked him repeatedly whether he had an affair. He repeatedly lied to her and told her that he was not involved with anyone else.
Alex.
We did learn through use of a private investigator that he was involved with an affair, and that his regular practice was to leave the house early in the morning, 6 o'clock, 6:30. He would leave the marital home. He'd go to the home of his girlfriend. He'd stay there in the dark for several hours. And then he would go from there to work, which was, of course, contrary to what he represented to
Look at Alex. Alex like, if this bitch could shut up.
his wife. This was
Or
important
you know what? Alex is probably over there texting his girlfriend.
to the court because we hear him now talking about his involvement with the child. Nothing could be further from the truth. He preferred and he took efforts to spend time with his girlfriend rather than the child. He did this not only in the morning, but also in the evening and also on the weekends.
Dang, Alex.
The second thing that we wanted to respond to is with respect to his claimed involvement with the child. My client has been able to recreate some information for me using texts from him as to where he is, whether he's working or not, based on her recollection. For example, in July, he only spent a handful of hours with her. That did increase in September to about 2 hours a week. In mid-September, he started picking her up from daycare. But the reality is that he was working, ostensibly working, on a regular basis and not returning home until the child was in bed.
Talk about being a single mom in a marriage. I know she has it tough. And
November
still got her pregnant with another baby, but now you want to divorce her?
7 was the last time he even attempted to give EJ a bath. And so if you think about that, that's been several weeks since he even attempted to. It was a disaster. Child was screaming, regularly expressing preference to being with her mom, which is not of any surprise given his regular absence.
See, when kids are with dad, they're supposed to be like, oh, heck yeah, this is my turn to get all of the toys and all the bubbles because dad doesn't know how Bath Nut runs when it's just us. I'm so scared.
True that he took care of EJ for a weekend in October. And I don't know how well that went, but the reality is that right now he wakes up in the morning. Now he's hanging out a little bit more. He kisses EJ in the morning and then goes off to work. Last night he spent 3 hours with her from 4 until 7. He comes home. The child immediately runs up to mom. She's crying. He had not changed her diaper. Child has a rash. Mom is trying to take care of that, does her routine. Dad is not anywhere around. He sings songs. She reads books. Again, dad's in the house, but not anywhere around.
Not present.
Finally, he shows up, kisses EJ goodnight, and he leaves. And then mom is left with a process of putting her down for bed. So he leaves before she even goes down to bed. Our request, Your Honor, is that clearly mom is the primary care provider of this child. I appreciate dad's attempts to become more involved recently. We're glad for that.
All of a sudden.
We think that a transition is appropriate in the facts of this case.
And he lived with
we
the
are
kid.
suggesting that he move out immediately and that he begin and try alternate weekends that would include one overnight, which would be an alternate Saturday. And then additionally, with
this is what I think happened with Tim and Akira. I think he got kicked out the house.
regard to his parenting time during the week, that he have Wednesday afternoons, something such as 4 until 7. I want to point out that this is more time than he has historically ever had with this child.
That's a shame, Alex.
Mom should be awarded physical custody.
Absolutely.
That's what the facts show. despite his claim that, he has a new pattern of taking care of the child. That is absolutely not correct. The situation here is quite unique given my client's pregnancy. She's 37 weeks. This has been enormously hard on her, a very, very difficult burden. And it's not made easier by the fact of dad's practice right now to basically come in, kiss or see the daughter, and then he slams down a glass of whiskey and heads out for the evening to spend with his girlfriend. This has been very, very hard on her.
That's what you've been doing,
He is
Alex?
very, very bold with regard to his relationship with his girlfriend right now. The good news is that his father has a lovely home, very lovely home, many bedrooms. He can go there immediately. Apparently, there's even a crib there. There's a high chair. It's already set up for the child. I understand that is not a long-term preferred residence for him, but it seems as though he's spending most of his time with his girlfriend anyway. So he's really looking for a temporary arrangement where he can take EJ. We would ask that he...
Lawyer said, might as well. Since he want to be over there all the time, go hang out with your daddy. Your daddy got room for you. Don't be all up in her house. She is pregnant. She do not need this extra stress. Bye. I agree.
Be ordered to move out of the house on Sunday. This wouldn't be the situation where he has to take all of his things out by Sunday, but he can certainly pack this weekend his clothing and personal items, move into his dad's house, and stay there temporarily until he finds longer-term housing. He has told Danielle that he's located an apartment that would be available December 1. I don't know if that is still available for him, but that is an option for him for a few days. But we would implore the court to ask that he leave the house and give her exclusive possession.
Take your ass over to your girlfriend's. Why ain't she even encourage you to move in with her since y'all so happy?
As soon as possible. I wanted to note that in a conversation that Danielle had with Mr. Campbell recently, she said to him, "Are you going to at least apologize for what you did?" And he said, "For what?" And it is this type of arrogance that is creating significant emotional distress for my client, which absolutely impacts the health of the unborn baby. So we need to end this now and have him move out on Sunday.
Get your shit
with respect to the financial situation, the good news is that if you order the exclusive possession, which I expect for you to do, then we have agreed upon the terms of a status quo order. And so we don't need to address the financial situation right now. This is a very unique situation because when Danielle has the baby, she doesn't have the benefit of any maternity leave, so she has no income. That would be effective, I think, at the last week of December is when she's leaving her job for her maternity leave. So our request today, Your Honor, is that she be awarded physical custody, that the parties share legal custody, that we begin transitioning dad's parenting time for one overnight on alternate weekends and Wednesday evenings from 4 until 7 p.m. And then finally that he move out and that Danielle be granted exclusive use of the marital home effective Monday. Thank you.
Ms. Judd.
Thank you, Your Honor. Well, as the court can gather from the argument here and from the pleadings alone, the disparity of fact in this case is pretty significant. Is he in the house pounding whiskey and not around, or is he gone having an affair? This seems to be a little bit of a moving target, but as this court knows, simply because we have an oral argument about the history of the parenting time in this case doesn't make it a reality. And my client would wholly disagree with the recount today of the history, which I've outlined in the pleading that I filed. I can certainly respect that the sympathies here lie with the plaintiff, but the inflammatory allegations about my client being a cheater and ending the party's marriage, even if they were all true, don't undermine the reality that he is a good father.
Oh, girl, shut up. Boy, I knew as soon as I looked at how her eyes was done, how her hair was done, I said, I think Alex brought the wrong lawyer. See, Jenny, Miss Bryan, if you will, she know what she doing. She's like, look, this is the facts, Judge. You already understand how this thing work. He didn't want to be with her. She already pregnant and everything. He outside with his girlfriend. Tell his ass, go ahead, get all the way out if you want to be outside. And you can do it little by little because a little makes a lot. Stephanie coming in here. Okay, so we want to talk about him cheating, or we're going to talk about him drinking. I mean, is he an alcoholic or is he a cheater? You know what I'm saying? Like, make it clear. Stephanie, girl, do you realize how you're setting your client up to sound like, yeah, he might be cheating, but is he drinking? No. No, he's a great dad. Now, was the little girl crying? Yes. But that was because she was scared of him because he smelled like whiskey, not because he was drinking nor have a girlfriend. Where'd you get your degree from?
Plaintiff herself has acknowledged in text messages to my client.
Girl.
My client would reiterate here that this marriage, again, was over quite some time ago.
So I ain't getting divorced.
He believes that Miss Campbell knows this. Her position seems to have recently shifted when she advised my client that she would go to any ends necessary to make sure that he played as limited of a role in this child's life as possible, as well as the future child of the parties. This really is an unfortunate position that I hope is short-lived, but based on the recent allegations and the pending discovery that we have now, I fully anticipate that this court is going to be quickly placed in the position to weigh in on how much of a smear campaign is appropriate as leverage in a parenting time matter. My client shouldn't be placed in a situation where he has to gamble with job security and threats to his personal relationships with friends and family just because he wants to continue playing an active role in this child's life. Plaintiff herself has acknowledged the hurt for both parties in this relationship. I get that. She's further affirmed that the minor child is what matters.
Ooh, Stephanie, you getting on my nerves. She said the plaintiff already said that she was hurt enough for the both of them. If she's looking for an apology, why? He know that he hurt her feelings.
A text message was attached to my response. My client is sad too for the current state of the parties' relationship, and he wants nothing more than to keep this case limited to their child. But to that end, he is a dedicated and actively involved father, and he has no intention of being bullied into decreasing his parenting time with the minor child in exchange for leaving or any of that. There are no circumstances in this case. There was nothing attached to the motion. The only thing here is plaintiff's own desire to have him removed from the house immediately leading into the holiday season. I mean,
like,
there's no circumstances, even alleging abuse. There's nothing. But without backing himself into a corner here, like Ms. Bryan suggested, he is willing to leave. He is happy to volunteer to vacate the home with the understanding that the temporary arrangement be preserved between the parties. He's happy to afford Ms. Campbell an expectation of privacy, but the understanding here would be that the status quo be preserved.
Oh, is that?
My client is absolutely able to verify his position with regard to the status quo, with regard to the parenting time arrangement, and far more text messages than were included in my little sampling attached to the response.
Why you include them?
So I would request, if the court is inclined to do anything here other than maintain the shared caretaking arrangement that I had outlined and affirmed in a couple of text messages as a sampling, that we do a prompt and brief evidentiary hearing so as to demonstrate what the actual custodial environment for this child is before we enter a new order. He's had full weekends with the child alone.
Wow.
Without issue, multiple weekends, not just one. He's regularly put her, admittedly, and as verified by Ms. Campbell's own correspondence, there haven't been issues with this. There aren't temper tantrums. There's no evidence of any kind of that. In fact, there's quite the contrary. If you skim the messages that I attached, there's affirmation that EJ is looking forward to seeing him. Thank you.
Ms. Bryan.
Your Honor, the shared caretaking arrangement is
before the lawyer started, her eye was like, bitch.
1 hour on October 15, 1 hour October 17, 1 hour October 22, 1 hour October 24.
Not realistic.
Half hour October 29. A few hours on a weekend here and there. He leaves early in the morning. If Attorney Judd wants to confirm that with her client, she could ask him that. He leaves early in the morning. He goes over to his girlfriend's. He's not there in the morning because he's with his girlfriend until the divorce case gets filed. And then all of a sudden he's hanging around a little bit more in the morning, kisses EJ in the morning, and then takes off. Now, the evening and what happened last night is not indicative of this great relationship that Attorney Judd claims that father enjoys with the child. The child runs up to mom. He didn't change her diaper, and he doesn't even stay around for the bedtime routine, instead preferring to exit before she even goes to bed. Ooh. That is the facts of this case, because he's trying to use it as leverage. But this is extremely painful for my client under the circumstances to see him exit every evening and head out to see his girlfriend.
Yeah, I agree.
And then returning late at night, early hours of the morning, or whatever it might be. So we would ask that
that's going to hurt any woman's feelings, not just a pregnant woman, but any woman who's married and has a man laying next to her, and you know that he's going out to see another woman, then coming home in the morning like it ain't no problem. Oh no.
Yeah, primary parent in this case, at least based on what I have today. So I will grant sole physical custody to the mother.
Yep.
Joint legal custody of the parties. Parenting time would be alternating weekends.
Same as always.
With 2 overnights. And Wednesday evening or afternoon from 4 to 7 p.m. It sounds like the parties are agreeable to a status quo order regarding expenses. And the defendant is to leave the marital home on Sunday, November 24th, 2024 by 5 p.m. And after that point, the plaintiff is granted exclusive use.
Now, is that exactly what's going to happen when it comes to Brenay and Devin and Tim and Akira? I don't know, but I do believe that this is a good example as to how courts do not play, whether it's a male judge or female judge. When they have the most privileged man in America, which is the white man, they don't care. If you don't follow court orders, if you are trying to hide money, if you ain't doing what they ask you to do, it's going to be a problem and there's going to be consequences. This ain't social media. This is real life. So I just wanted to kind of put that out there and see what we would think about it. Let me know down in the comments. I have been the Jess Case in Red. I'm so thankful that you guys tuned in. Please make sure to like the video, share it with a friend, hit your notification bell so you catch me each and every single time I come on, and I'll see you guys in the next video.